Alex here with part 136 of the My Docket series on child custody and visitation. As with my previous videos, I'll take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's the video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened, and that's because my ex's parental rights have been terminated. Number two, the nutshell version as to the purpose of the series is to give my viewers one big example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. We go now into the court's writ of mandamus. This is the final written order that I discussed in the previous video. My mindset, of course, is really, 10 out of 10, super happy, excited, and in fact, he gave this to me on Christmas Eve, so I remember thinking, what a nice Christmas present to finally once and for all have squashed this annoying issue. No more fictitious address, no more so-called victim of DV, no more of this nonsense. We are moving forward full speed ahead. And again, guys, this is the first domino in a series of dominoes that's about to topple in this case. This, you will see, this writ of mandamus has a continuous impact on this case. Almost every turn, it impacts my ex. And I'm going to bring it up anytime that I see that. Another thing I want to mention is that I noticed that I did not file a notice of entry of order on the entry of the writ of mandamus. I should have done that. Luckily, my ex wouldn't really have the right to appeal because she didn't participate in the proceedings at all anyway. So it's possible that under the rules of civil procedure, I didn't even have to file a notice of entry of order. So now I'm scratching my head here, literally. Saying maybe I didn't even have to file a notice of entry of order, but it is safe to do this because that's what's going to start the time to file an appeal for your opponent. So, erring on the side of caution, I've seen a lot of attorneys file notice of entry of order anytime an order is entered, just because they don't want to risk the fact that all of a sudden 6 months later their opponent files an appeal. They want to get that time clock ticking. They want to stop any opportunity to appeal as soon as they possibly can so that they can continue to move forward in a case and not always have to look over their shoulder. Anyway, at this point in time, I think we should go ahead and take a look at what the judge has filed. Here we have the writ of mandamus. I know I mentioned this in the previous video, but I will reiterate that I don't think that the way that the court did this was the correct way to do it. I don't think that judges are supposed to enter and sign writs of mandamus. I think that they are supposed to enter and sign order granting petition, and then at the very bottom of that order, they should be stating something like, I hereby direct the clerk of the court to issue the writ of mandamus. That's what I've seen the Supreme Court of Nevada do a million times. I've never seen them do it this way. I'm not sure that the district courts are supposed to do it this way, but I'm not going to get into something that technical because it didn't impact my case, and I'm not really 100% sure anyway. So let's go ahead and scroll down. The above entitled matter. So this is a standard introductory paragraph by the court. He is summarizing the fact that I appeared representing myself, the government appeared through and by its attorney, and my ex failed to appear. He goes into his first assertion. I hate when he reiterates everything, but it's not too much, I guess. He references my petition for writ of judicial... No, wait. He references my petition for judicial review in the other case, and he mentions that it was denied. He then goes into my original petition for writ of mandamus in the Supreme Court challenging the issuance of the fictitious address. He mentions Justice Cherry's publication on my writ of mandamus under Falcone v. Secretary of State, which expanded Nevada case law. He goes into the Supreme Court of Nevada's specification of the procedure that he was required to follow in determining whether to disclose the confidential address of my ex. He mentions the burden of proof that was on my ex. I think he's mentioning just the procedure here. Yeah, he is mentioning the procedure and the burden of proof, which is good. He goes into the next assertion. Pursuant to his order filed October 19th, 2011, we share joint legal and joint physical custody, and therefore I have met the initial burden, demonstrating that I am entitled to know where my ex resides. Then he goes into the next paragraph and he indicates that my ex was served at her last known address of record, and that pursuant to Rule 5, she received proper notice of the hearing, My ex failed to appear and present any argument. She has not met her burden of proving that I am a perpetrator of DV. Interesting how when it comes to not needing to show any proof, oh my goodness, she is so eager to go and file this application and get her application, her fictitious address. And now that she has to show proof that everything that she's saying is true, oh my goodness, all of a sudden, no, she doesn't want to go and do that. That's just scary. So anyway, now that she has to prove it, she can't do that. She completely fails. She doesn't even show up. Next assertion here. The secretary testified that it takes no position as to the substantive questions, and they basically are not going to defend my ex. That's not their job. That's not what they're going to do. Therefore, my petition is granted, and the court directs the Secretary of State to disclose my ex's confidential home address to me. Going into the next assertion here, we have a certificate of mailing, which is indicating that the judge mailed this document to both me and my ex, as well as the Attorney General's, the assigned Attorney General, assigned deputy, which is Kevin Benson. And that's it. The court has disposed of the petition for writ of mandamus and ultimately this entire case. He disposed of that petition by granting it and issuing a writ of mandamus commanding the Secretary of State to turn over its fictitious address, to turn over the real address for my ex to me. Going into the aftermath, I filed nothing in this case, so I incurred, or in this particular video, so I incurred $0 in costs. My ex is not participating, so she incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. And again, my ex is not participating, so she incurred $0 in attorney fees. The government has not filed anything, so they incurred $0 in costs. And the government probably would have at least spent enough time to review the document, make sure everything was in order so that they can actually comply with the court's order. So I think it is reasonable to say 15 minutes again. They knew it was coming. They were at the hearing. They read the minutes. None of this is a shock to them. They just needed to sort of officially put it into their system and comply with the order. And I think under the circumstances, 15 minutes is reasonable for the government's attorney. At a rate of $250 an hour, that's going to come to $62.50 in attorney fees for the government. As with my previous videos, if you have any questions, you can feel free to post them down in the comments below, and I will see you guys next time.